Hello and welcome to the Of Interest podcast. I'm Gareth Vaughan from interest.co.nz. Interest.co.nz recently ran an article co-written by a leading anti-money laundering barrister and auditor raising concerns about planned job cuts and changes afoot at the Department of Internal Affairs, which is one of three New Zealand Anti-Money Laundering and Countering Financing of Terrorism Act supervisors. They describe these changes as a travesty in the article and a huge backward step for the country, risking getting New Zealand added to a damaging international grey list. The authors, barrister Fiona Hall and anti-money laundering auditor and consultant Martin Dilly, join me to discuss their concerns about what's going on at the Department of Internal Affairs, or DIA, and broader issues around New Zealand's efforts to combat money laundering and terrorist financing. So hi Fiona and Martin, and welcome to the Of Interest podcast. It's great to have both of you here.
Great to be here, Gareth.
Thank you for having us.
Look, I guess maybe to just kick us off, can you tell us a little bit about yourselves just so the audience can get a feel for who you are and what you do?
The first thing I should probably correct that I'm a barrister and solicitor because the Law Society get a bit finicky about that. So I'm not a barrister sole, I'm a barrister and solicitor. But I am in sole practice and have been for about 8 years now. And regulatory law has always been my focus, but I would say now 95% of what I do is probably in the AML space, just because there is so much need for help for reporting entities. My background before that was in-house counsel, and I always say I've sort of walked the walk because I was an AML compliance officer myself, so I have a lot of empathy for their role and what they've got to do. And I've also actually prosecuted because I was at the Commerce Commission as a prosecutor, so I've done the regulatory side too. So I've done sort of the corners of the triangle. So I think that's maybe gives me a different perspective when I'm looking at it.
Yeah, very thorough one. And Martin?
I also come from a legal background, so I started as a corporate solicitor and then moved in-house doing legal and compliance for an international bank. And it was really through there that I very quickly moved on to the covering compliance, which included AML at the time. So won't bore you with all the extensive history of the various places I've worked, but I've been doing some form of AML since 2005, including international AML requirements for the bank. But also I've been exclusively working in AML consulting and auditing since 2012, and I continue to do that. So yeah, I'd like to say there's not too much I haven't seen in that time, but
including auditing the business I was with. So,
yeah, right.
So Martin and I met actually when I was with the Commerce Commission, and I was questioning him, and the next time we met, he was auditing me. So
right, okay,
we have a long history.
Yeah, absolutely, great. Well, look, that's great. Thanks. Look, and I guess, obviously, you guys live and breathe anti-money laundering regulation and all the issues that comes with that, which there are many, and we'll get into those. But I guess for people listening who maybe don't have the knowledge that you have, this might seem like a bit of an esoteric area to them. So why should the public really care about, I guess, the efforts and impact of the fight against money laundering and terrorist financing?
well, of course, the overarching theory is that if you can prevent people benefiting from crimes that generate illicit funds, then they will stop doing that activity. So if you're not going to make money from selling drugs, then that will help in the fight against drugs. And fraud and scams are very big at the moment. If you could remove the ability for people to make money from those, then theoretically we should help prevent those crimes as well. It is just one tool in the fight against crime. Other things that people might not think so much about, things like the distortion of the economy and markets. There was a study once where they estimated that property prices in Sydney were elevated about 20% due to inflow from organised crime. So that's pushing house prices up 20%. So that means that the average public person has to pay more for their house because of organised crime. Shops that might be laundering fronts or accepting laundered money from gangs. If you are a cafe that is trying to compete against another cafe that has an inflow of funds to launder on behalf of a gang for a cut, you are not going to be able to compete in the long run because they can adjust their prices taking that into account. So it's all this distortion. Tax is a big thing at the moment. Everyone's talking about tax, but lost tax revenue. So if people are laundering money and they're not paying tax, then that burden then starts to fall on the rest of us. So it's really about reducing crime and making sure that we're all in a level playing field in the public.
And I think for the general public, what happens is all they see is the additional work they have to do. They go to open a bank account and they've suddenly got to do all of this, get all this information. They want to sell a house and they've got to provide evidence of how they afforded the house in the first place. And so there's a lot of frustration out there without actually understanding what is trying to be achieved. And obviously we'll get into whether or not we think the requirements are appropriate, but putting aside, if you look at the actual purpose, I think if you spoke to anybody on the street, they would all support the purpose because no one wants drug dealing in the community. No one wants child exploitation in the community. And that's actually what we're trying to stop. It's just we seem to be using quite a clumsy tool to do it. And I think there hasn't been a lot of education of the public. So, and again, we'll probably get into how we came about to have this legislation, but very briefly, the international world is what drove us to complying. We are a small economy. We rely on international trade. So we were really forced into bringing in law, which meant it came in, but no one really told the public about it and explained why. And I think that has had a terrible roll-on effect. Yeah,
I think that's a very good point. As someone who's written about this area for a while, I think that's a good point, and we'll definitely get more into that. But let's go back to the Department of Internal Affairs, DIA. So what are your specific concerns about what's going on there? And if you can sort of tell us, moving beyond that, your concerns ultimately about the grey list and the possibility of that as well.
Well, I think what gave us the most concern is where we saw the announcement that they were planning to cut around 40% of staff from the AML Directorate, which is the team that handles AML regulatory and supervision within the Department of Internal Affairs, or DIA. What gives us concern is that we know how stretched the supervisors have been. So any cuts to those areas give us concern that that's going to affect their ability to enforce and supervise this act. We'll come back to what that might mean for for the clients we deal with in a minute. But on a bigger stage, the concern that is if we cannot demonstrate effective supervision of our AML regime, when we get evaluated by the intergovernmental body, the Financial Action Task Force, or FATF, when they come and do an evaluation, they look at whether we're technically compliant with their recommendations, but also are we effective in implementing. And I'm hearing from people within government departments, and including, I think this was also mentioned as a potential issue by a representative from the Ministry of Justice at a recent conference, that there is a real concern around both our technical compliance and our supervision. If we are already concerned about that, reducing staff by 40% is going absolutely the wrong way. I think what also gave us cause for concern, though, was that the cuts didn't seem to reflect any sort of wider thinking in terms of structure. We have talked with Minister McKee previously about the state of AML in New Zealand and how we do have 3 supervisors. And I believe there is a movement towards trying to move towards a single supervisor, which will make a more streamlined, more efficient regime. Now, the proposed cuts to the DIA, in our view, go against what that's trying to achieve. And in particular, some of the roles that have been singled out to be disestablished are some of the key people that we would have thought would be needed to actually implement a single supervisor model. We're losing, if what I understand are the key roles, we're losing the people who've been involved in the mutual evaluations. We're losing the people that have written all the guidance. We're losing the people that have prosecuted the few cases that we have taken for breaches of the Anti-Money Laundering Act. That is a huge loss, and they will not be able to be replaced. And that then makes everyone's life harder because...
I think I'd just like to add, it's not for me to tell the government how many people should be employed within agencies, but I think if you are looking at a restructure of the type we're talking about, it would make sense that you would restructure first, then you would work out who you wanted within that agency rather than culling hugely from one of the primary agencies. And the other thing that for me a concern is the DIA supervised the widest range of reporting entities. And certainly my personal experience is that they have been the supervisor most open to engagement. And if you look at the actual act, there is a set of functions for the supervisors, one of which is to educate and support. And the DIA have done that most effectively. Interestingly, alongside that, they are the ones who have been taking the cases to court. So they have been the most proactive, really, of the supervisors. And I had to laugh because I was reading some of the comments. You probably should never do that after you've written an article. And people were saying that we must have been get our work from the supervisors, which is quite laughable because if anyone read any of our previous articles, they all criticise the supervisors for what they're not getting right. But this to us is intrinsic to having meaningful, workable legislation, and we just seem to be going in the wrong direction in our view.
Just to pick up on a point there, I think that we should just make sure people understand is we talk about three supervisors. So obviously Department of Internal Affairs is one. The other two are the Reserve Bank and the Financial Markets Authority. So we've got three different entities who are supervising anti-money laundering and financing of terrorism acts in New Zealand. So just so people understand that.
Yes, and they are supposed to work together and they meet regularly and they release joint guidance. But our experience is they all have very different agendas and we really lack consistency. And I guess when this regime was first introduced and I was a compliance officer, the last thing I was concerned about was that there were three supervisors. I just wanted to know who my supervisor was and how to fulfil what they wanted. But I thought that what would have happened is we would have evolved into a more mature regime by now. And I think the three supervisory model has actually prevented that. We have huge turnover of staff. We have staff moving between the supervisors. We seem to have these power battles for whose interpretation is going to apply. And I think, given how long the legislation's been in, we're not as far advanced as we should be.
So the Reserve Bank obviously supervises the banking sector, non-bank deposit takers, that type of stuff. Who does the FMA supervise and who does the DIA supervise?
Essentially, FMA supervises those entities that it would already supervise for something else. So
fund managers and the like?
Correct. Share broking, custodians. There's some where they would pick up for entities that wouldn't otherwise be captured for, say, who work in more of the wholesale investment space that might not fall under the FMCA, for example, but they would still get picked up being, FMA is the most relevant supervisor. DIA picks up everything else. So casinos, which they've always had, all other financial institutions, and then lawyers, accountants, real estate.
And all other, you've got to think money remitters, people who aren't, prior to this, who weren't commonly used to being heavily regulated. Your small tier lenders, they've got the virtual asset providers, they've got the bulk of that work. So they have a huge space, the racing industry. They've just this huge space, which I think has meant they've had to turn their mind to more to the legislation and how it applies more carefully perhaps than the other two supervisors where it's more streamlined. And, the Reserve Bank just takes this big approach to its entities based on banks, basically.
Okay, so in terms of that international, pressure in this area and monitoring that we get from the Financial Action Task Force every few years, if we are deemed to not be doing this very well or have things wrong, that grey list is sort of hanging over our heads. I guess if we do get a bad report card from the international watchdog, what would that mean for New Zealand?
Interestingly, the International Monetary Fund did a study on what the outcome was from being put on this grey list for countries. And in terms of what their study found, I think the biggest one that gives me the most concern is that they showed that capital inflows declined by, on average, 7.6% of GDP when the country is grey listed. And also foreign direct investment inflows declined by on average 3% of GDP. So that would be devastating for New Zealand if that occurred. Not saying that's going to happen in every case. Maybe we might be viewed differently from other countries that it got added to a grey list. But that should be enough to set off some alarm bells somewhere that, this is a very high priority for New Zealand.
I probably don't have much to add to that. I think, Martin, you are more across what FATF do, but I guess my concern too is just general reputational damage and trading, because our trading partners do ask. All my clients get asked with their international deals, what are your AML protocols, what are your procedures? And that's why you then get this flow-on effect, which could have both huge economic impact. And I think reputationally, New Zealand's seen as this clean, green country, and that really has the potential to go down in flames.
Now, Martin, you, in your efforts to get to the bottom of what's going on at the Department of Internal Affairs, you made an Official Information Act request. Has the response you got to that eased or raised your concerns, and why?
It was very interesting to go through this process. One is to try and decipher government speak. And we'll get to some of the terminology they use there. But for me, it actually shows a pattern of under-resourcing of the AML team within the DIA. I think that was my major concern. At certain times over the last 5 years, they were essentially budgeted to have 55 staff members. That's what they had determined was necessary, especially with the implementation of Phase 2, which is bringing lawyers, accountants and real estate into the regime. 55 staff were apparently needed. Now, the information provided shows at no point did they ever hit 55 staff. They've been consistently below that. In the financial year in 2022, they only had 37 staff instead of 55. I understand there was some hiring freezes going on. So that gave me concern that they've never ever had the 55. So the question becomes, why is that? One of the other questions I specifically asked was, has any of the budget been reallocated from the AML team to other areas of the Department of Internal Affairs? And we get some government speak here. So one of the things they talk about is they don't talk about reallocation. They use the terminology, a permanent reprioritization of constant underspend. And my question is, well, what does constant underspend mean? Why would you be underspending your budget in an area where you are tasked with implementing AML and educating and supervising these new entities? And my only thinking is that has to be simply that they've been refused expenditure of some of their budget.
And I would agree, having come from Commerce Commission, I know there would be a huge panic if we weren't using up all our budget, because if you don't use up your budget, they cut it the next year because they say, well, you clearly didn't need it. So there is no way that I read those figures and see that as optional underspend by the DIA.
Yeah. And they've indicated some areas where they reallocated too, but they didn't provide figures in this first response, which you feel would have been inferred from the fact I asked about how much, how they reallocated it. But they reallocated this constant underspend permanently to operating expenses in the digital safety function, the policy function, and they also did a one-off reallocation to fund capital for an operating swap for software as a service across the department, for whatever that means. What we don't have is figures there, but essentially we're having the AML budget reallocated away from the AML team to other areas of the DIA. I'd say chronic understaffing, which in my view is difficult then to defend as being effective supervision. If we decided that it was 55, if we don't have 55, then we are under-resourced.
So I guess this brings us to a broader point here that I suppose it's a bit of a partnership between the public and the private sector. So the public sector are the supervisors, the rule makers, the rule enforcers, and the private sectors, the likes of yourselves who are working with businesses who are required to comply with this law, and then just general, citizens and business people who are expected to be good citizens and not launder money, and if they become aware of any, report it. Is the public sector pulling its weight here?
It's a fascinating question, and look, I'm the first to say I believe in this legislation. I've always supported this legislation. It's probably why I got so involved with it so early on. And I've always said my clients need to do the best they can to comply at a good level, not just your basic level. And it's getting harder and harder for me to maintain that position because more and more compliance is being heaped on these reporting entities. They're almost being considered pseudo-police, in my view, in the level of detail and investigation they're expected. And you hear the FIU regularly, the Financial Intelligence Unit, that is, who collects the data who collects if somebody forms a suspicion and files a report, that's where it goes. And you regularly hear from them, we don't want it unless it's really good. We don't want it unless you've done X, Y, and Z. And it's like, you look at a small business and half of their staff are doing compliance. And I am now in a position where I'm trying to find ways around regulation rather than helping my clients comply with the regulation because it's simply too difficult, expectation is too high, and I think we have inconsistent messaging from supervisors and supervisors who seem to, maybe because there was an underlying criticism in our last FATF report that there wasn't enough happening from the supervisors in terms of enforcement action, that they are picking very low-hanging fruit, and I don't think they're necessarily investigating and looking at the areas they should. They are trying for quick wins, and that's not in everybody's interests.
I guess also I'm interested because you're obviously working, your clients are people who have to abide by these laws, and if the supervisors are understaffed and maybe a little bit underwhelming, could that not possibly be good for your clients?
It's one of these challenges that the reporting entities are expected to be meeting their obligations. One of the key ones is reporting suspicious activity. So a failure to report suspicious activity when you should have carries potentially very heavy fines, but also potential criminal liability for failing to do that. Now, so entities are very strict about trying their very best to detect suspicious behaviour and report that. But talking with someone who'd previously worked in the FIU yesterday, they are still of the view that our Financial Intelligence Unit is very reactive. So yes, they are collecting all this information and putting it in the database, but there's not a lot of intelligence being applied to that to actually investigate it and look for patterns. Very much when there's a criminal case or there's a potential suspicion around a person, they will then look in that database to see if they can find it. But that's not, so it's going backwards from there, not creating it. So you'd like to think if you're doing all this work to create these SARs that they're being used to the absolute end of their usefulness.
These are the suspicious activity reports.
Yeah. So if I've bothered to do all my work, and as Fiona mentioned, you're often tasked with doing a lot of digging into people's source of funds, source of wealth, and getting all this information together for them, you hope that's being used. And a big criticism is that they don't hear back from the FIU, whether Financial Intelligence Unit of the police, whether that's been useful or otherwise. But I was thinking about this. What if every reporting entity was following to the letter of the law this act? They were doing their absolute best, and they were finding the large majority of money being laundered through their entities in New Zealand, and they were putting in those reports. Would the government have anywhere near the capacity to actually use those reports and enforce them? And the answer is no. I know your previous guests from the war on dirty money, they highlight this point in relation to the UK, yes, which is that the police are simply not resourced to investigate and prosecute money laundering. And we see that here to some extent. We're very good at proceeds of crime and confiscation, but in terms of actually prosecuting money laundering offences that are aligned with the predicate offences that has generated the funds, we tend to just not bother because it can be tricky. we've already got them on the predicate offence, we don't worry.
And can I just say, from a legal point of view, one of the reasons with where we're so successful with seizing assets is that from a legal perspective, it's a lower threshold. They do not have to prove it. Beyond reasonable doubt, they're allowed to seize first. So that's why that legislation is used so proactively by the police, because it's easy. And it's hard to get your assets back once they've been seized.
Absolutely. And it's a great headline for them, right, if they've busted a gang. And an interesting comment, I was talking to a contact of mine this morning who works in AML compliance, and this is what he said, almost word for word. To get police attention, you have to take a suspect and plonk a Comanchero sticker on his back. So they're very interested in gangs, but not necessarily interested. That's
possibly true. I'd also just like to go back to your comment about people being probably excited that maybe the DIA numbers are being cut. It's a terrible thing. I have heard some reporting entities clapping their hands with joy if they're supervised by the DIA, but it's not the good reporting entities. And I like to think that most businesses are good businesses that want to comply with the law. And the risk you have is, sure, if there are far fewer DIA investigators, you're less likely to get a knock on your door. But the problem is, if you do get a knock on your door, you now might be being investigated by someone who really doesn't have a good handle on the legislation, let alone a good understanding of your business. And you are going to be in a much worse position, let alone all of these other potential economic, downflows that are broader, that will affect your business in a broader way.
Yeah.
I think that raises an interesting point also in terms of the public sector carrying their weight. Is when you are resourcing these regulators, it's not just about the quantity of people you get. It's got to be about the quality and the experience. And I think we've seen increasingly that, we are seeing people who are being classed as senior advisors within entities who have a couple of years' experience in AML.
6 months.
And in some cases, no experience in the sectors that they are supervising. And that just seems totally wrong to me, especially in areas like the FMA and the banking, the FMA sector. You've got very experienced compliance people there, and they're getting essentially graduates coming and telling them what they're doing wrong and why they think their business might be a different level of risk from what that experienced compliance person thinks. And that's madness to me. I always figured the regulators would be staffed by those people who had been there and done that. They've worked for different places. They've done this before. They know what is possible and what should be getting done. But we're just not there at that point. And that results in very poor outcomes.
And very, very makes it very difficult to comply to. I have a number of clients who are supervised by the FMA who really struggle to respond effectively. So the FMA will make inquiries, but the language they use, is not appropriate to the business. So you're sitting there trying to interpret what exactly is being asked of you, because it's not really the speak of that sector. Both Martin and I have come across Reserve Bank sending people with no banking real background in to undertake an assessment of banks. And it just does seem wrong. And it also comes out at the other end where they will risk rate particular entities, and entities can seek an exemption, a ministerial exemption. And there are two aspects of probably exemptions we should flag at the moment. Is the ministerial exemptions have always been messy. They've always been time-consuming. But our understanding at the moment is that there is no one assigned to review ministerial exemptions. I have 2 clients who have been waiting nearly a year with no feedback, and I've had no update from the Ministry of Justice that someone has been appointed. I don't think that's acceptable. These are fledgling businesses, they're innovative, and one of them, and it'll hopefully make people laugh a little, they're probably not my poor client, they help manage payments for schools. So they collect the school donations, or more significantly, they do things like they fund, arrange the school lunches, the uniform shop, and they would like to be able to sell tickets to school shows. They have been deemed high risk of money laundering. And I mean, I sat with the minister and said, look, how does buying 2 pairs of grey shorts from a school uniform shop ever get anywhere near, I mean, this is where I'm going to launder my money. It is ridiculous, particularly when the flip side, and I'm not for one moment suggesting these industries should be caught, but I'm just pointing out that they're not. iTicket, Ticketek, Ticketmaster, none of those are considered reporting entities. Yet they sell tickets to shows. How are they different? Travel agents aren't caught, but they have trust accounts and manage funds. So we have this real disconnect, in my view, even about who is and isn't a reporting entity. I don't think that discussion has been resolved at all, years on.
That moves us on to, I think, a good question that I was going to throw at you. So you mentioned before that the Associate Minister of Justice, Nicole McKee, who is seemingly in charge of this area, she says she says that reforming the Anti-Money Laundering, Countering Financing of Terrorism Act is one of her priorities this parliamentary term. So what would you, I guess, like to see her do? What do you think the focus should be of this review, and what do you hope that she's able to achieve?
As mentioned before, I think there is a desire to shift from having 3 supervisors to 1 and the efficiencies that could potentially bring. I would personally like to see that being a standalone supervisor. I think the results from the OAA request to DIA show that if it's within other ministries, that you cannot trust them to not reallocate budget, whatever language they want to put on that. The other point I would really like to see is a move back to a more risk-based approach. The Act itself is risk-based. It's based, which essentially means that we accept that people have limited resources and you are supposed to direct those resources towards the areas of highest risk in your business. I think the piece that supervisors often miss also is risk-based approach means that I will not find every single piece of money laundering in my business because the cost to do so would be prohibitive. So, for example, you might be able to get 95% of the customers you on board get that right, get the right combination of IDs, identify the right structures. But closing those 5% errors can cost as much as implementing the first 95%. So that's what I think has been lost somewhat in the implementation and supervision of this Act, is that as long as entities are in good faith doing their best and doing an appropriate amount, we have to be more tolerant of allowing them to take an approach that is more suitable for their business and is in line with their actual risks.
I totally agree. And look, I'd like to say, I think the minister's been tasked with a very difficult job because this problem has been years in the making and she's really got a small window to do something. So she can't tackle everything. She was very generous with her time with us, and I know she has been with others as well. She is really committed to understanding the issues here, but she is going to have to obviously target a couple of things that she can achieve. I would like to see that, as Martin said, a standalone a supervisor. But I guess the backdrop against that is subsequent to our meeting, we've had these announcements about the DIA, so that causes us concern. The other thing I think I would like to see somehow is a little bit more control, actually, and supervision of the supervisors, because who's monitoring the supervisors? Who's supervising the standard and quality of their work? Who's looking at their consistency? There is no transparency in their decision-making. They don't publish it. We find out that they've taken a stand on something because we get a report, because we're acting for a client, not because it's published. I've got another client, another one who's waiting for an exemption. I think it's a great model. It's designed if you're building your fence or something, you've got a tradie coming in that the money comes in and they hold that money. So the tradie's protected, you're protected until the work's done. And the battle here and the reason why there's an exemption application in is because the supervisor has determined that, I don't know for listeners if they'll understand, you've got to do customer due diligence. So if you've gone to open your bank accounts and you've been asked all these questions, that's officially known as customer due diligence. you've got to define your customer. Well, in this instance, they've said the customer just isn't the tradie who is actually the one who's buying the service, it's the person using it. Now, if that is the true definition, and I legally think it's wrong, that creates such an onus on this small, new, fledgling business and cost. To what end? How much money laundering is really going to be happening here? Why is there so much risk? And I think the supervisors have got a little bit nervous maybe in making some of these decisions. They certainly don't seem to be prepared to go to this risk-based approach, and I think they need more direction themselves in that regard.
Should that come from the Ministry of Justice?
I think it'll probably have to. What you've got to remember is the DIA are operating under the anti-money laundering legislation alone. The FMA utilise their powers under the Financial Markets Act in addition to the AML legislation, and the Reserve Bank do the same with the Reserve Bank Act. So they have additional powers. So, for example, the FMA have a power to silence. We sweetly call it a gagging order. It's a confidentiality order, if we use the proper term. So in the interests of an investigation, which you can understand, they don't want everybody talking, they will issue a confidentiality order. They've got the power to do that. The DIA don't. So we even have an imbalance there between the supervisors when they're investigating somebody. It's, as I say, there's a lot for the minister to digest here. But those are the two things. I'd like some sort of model. And one of the things that Martin and I spoke about was, and Martin, you know more about this again, is the banking model that you referred to in the US, that they're required to be transparent. Maybe you could...
Yes, and I can't recall the acronym off the top of my head, but essentially the banking supervisors put out a manual that this is our manual of how we supervise and what we look at when we come on site, so that you know that you can prepare your policies and processes against that manual, knowing exactly, transparently, this is what we're coming to look at. And that, I think that is, that is a high watermark of regulatory transparency. But I don't see any reason why, if they are using checklists and they have within their departments, views on interpretation of certain sections of the Act that they are going to apply when they come in, that those should not be made public. And then, sectors can look at those interpretations and challenge them. What we have at the moment, as Fiona mentioned, is that you often only see their interpretation when it ends up in a review report that you then have to challenge. But at that point, you are one entity going up against a supervisor. And I can tell you right now that often the compliance people will say, these findings are wrong. The number one complaint is they do not understand my business, but the board do not want to fight it.
Because there's an ongoing relationship that they've got to maintain. That's usually what I hear. And that's a real concern. There's an imbalance of power. Yeah.
It's divide and conquer. If taking on entities one by one, each entity will fold every time because the cost of defending and arguing it is too difficult. But if these things were made transparent, if these views were made transparent, then as a sector, let's take share brokers, for example, they could get together and say, actually, that interpretation makes no sense for our business. As an industry, we would like to challenge that and have an open discussion around how we actually implement this obligation in a sensible way to try and achieve what we're both trying to achieve here, which is to reduce money laundering.
And I think that with that transparency, you would get greater protection for the small businesses because they would see and understand. And I think it would inevitably flow into a more risk-based approach. So those are the two areas I think I'd like to see the greatest focus in.
So, potentially a ministerial review looking to reform AML CFT Act. There's a lot that could be on the table here. And I guess time will tell exactly what is on the table and what they can agree on, because, of course, it's a three-party government, so they're all going to have to agree to push things through. But one of the points that we seem to come back to quite often is education. And Fiona, we've discussed this previously. And I guess we're talking about the supervised, the reporting entities needing to understand what's expected of them, but also the broader public, because you note, noted before, I mean, just opening a bank account, for example, I mean, that can be annoying. There can be a lot of friction there for the average person, and a lot of that's to do with AML. So do we need to educate everybody more about this?
We absolutely do, because again, what you find is I don't think people are always telling the truth when they announce, well, you've asked me for this, but down the road I could go and take my business there and they're not going to ask me. I don't think that's necessarily the case, but that is rolled out continually. And I know a good example would be if you take the real estate sector. They are charged with doing CDD on their customer. Their customer is the vendor. It's not the buyer, which I always find so interesting because that's where the money is. It's the vendor. And often a property's been bought years and years before, and suddenly, the vendor's been asked to prove how they purchased this and how they funded it, and there is resistance. And I think the other thing that's often overlooked is we are a multicultural society, and we have real cultural differences to things like disclosure of financial status. And so sometimes it's not that people are trying to hide it, it's just there's a lot of cultural discomfort about talking about these things. And, you've got these poor compliance officers tearing their hair out, and they get from up the chain, well, so-and-so down the road, they're listing the property. We haven't got there. And again, you get this incredible disparity. And I think if people understood more what the business was trying to achieve when they were asking these questions, that they're not challenging them. I think there's one document that I've come across that's on the DIA website that is a form that you can print off and show to somebody about why you're being asked these questions. And I don't know whether entities use it. It's not. I think it's relatively useful. But we sort of need more of that. In terms of educating the actual reporting entities, I always hear we need more guidance, And I actually did a presentation a couple of years ago on guidance. And I said, it's funny, when I went to add it up, there was something like, and this is 2 years ago, 137 pieces of guidance. So it's not we need more guidance, we need the right guidance. And that's not there at the moment.
Having been at the start of this back in 2012, and this particular act came into force in 2013, the frustration from entities where they encountered that customer who'd come in and they said, oh, now we're going to need all of this from you. And they didn't have any idea why they were being asked. And so it was on each reporting entity to educate their customers as they went. Entities that are trusts, if you have a family trust and you need to open an account, you are subject to automatically to what's called enhanced customer due diligence, which means in addition to understanding all the individuals involved with the trust, I need to collect information on the source of wealth or the source of funds of the trust and take reasonable steps to verify those. And in a lot of cases, we go back to something like funds management, they have a lot of trusts. Their customer base is predominantly 65 plus. And they're asking them, can you verify where your money came from? Well, I'm retired now, but I used to do this. How much do you want? And you can appreciate then the frustration of the customers coming in, and the banks and every other organisation having to educate them on why they are getting this. And the scary part is it's getting worse. So in recent years, there's been an increased focus on things like, what is the nature and purpose of the business relationship? Why are you using my service, and how much and how often are you going to put money through me? So I got asked by my own bank, and a bank that I've been with for over 40 years, and the account that they're asking me about, I've had for 25 years. They have full visibility of every one of my financial transactions. And I was interrogated as to what my plans were for that account. And my thinking was, why would you rely on anything I tell you when you've got 25 years of data on my behaviour? If I was an actual money launderer, why would I give you a straight story? It's this sort of thing. And I hate to say, with these new regulations that came into force on the 1st of June, if you are a company, next time you go to open an account, or even potentially if they decide to update your records, they're going to ask for your constitution. They may ask for your shareholders agreement. The guidance even suggests you could ask for proof of capital contributions. They are going to, and that is not that they consider you necessarily a high risk, that is almost a standard thing that they're going to ask for. And to me, that seems excessive. And it gets back to that risk-based approach.
Who's going to read the Constitution? That's what I keep saying. Is someone going to sit there and read this Constitution? And what are they going to do with it once they have read it? I mean, could we have some sense to what these requirements are? There was this. We need to understand better, or we need to make sure that entities understand better the control structure of their customers. That's really what they were aiming for, but they've taken this enormous, hammer to this walnut, essentially. And I mean, I know the clients I've been talking to in the last week or so who have all been trying to implement these new regulations with companies. Every company they've dealt with, none of them have had constitutions. So they can't even get a constitution. Yeah. So it is a bit ludicrous, but I said this earlier, I had to laugh. I was at the supermarket checkout and I'd been having a particularly trying day for poor entities that I didn't think should be captured at all, and I was standing in line and I looked up and I was behind a whole lot of gang members, and I thought, I think I'm in the wrong queue. I should have gone to a different queue. And they were just buying lots of meat, lots of alcohol, and out came the wads of cash. And I thought, my poor clients who are down here spending all their money trying to comply, and really there's the money that we probably are looking for right in front of me. It seemed to be rather odd that I happened to choose that queue in the supermarket.
Yes, indeed. Look, guys, I'm sure that we could go on and on this, but I think probably it's a good point at which to wrap it up. And we'll follow developments with the Minister's review with a lot of interest, and Department of Internal Affairs as those job cuts go through, and see how that impacts you guys and your clients and the fight against money laundering. So thanks so much. So Fiona Hall, so barrister and solicitor. That's correct, yep. And also Martin Dilly, who is anti-money laundering auditor and consultant. And I'm Gareth Vaughan at interest.co.nz with another episode of our Of Interest podcast.